2.5 lakhs. Please switch off all your cell phones. All your cell phones. I appeal to all the students, kindly maintain high silence and observe the board proceedings. These are very important for each and every one of you. This is like a real court. When you go to court, you have to follow the same procedure. There will not be any change of procedure. The same procedure will be followed in the real courts also. Right? Okay, thank you. Maintain high silence. Let's start.
The council seeks permission to approach the dance. Much of that. The council seeks permission to address the bench as your lordships. Much obliged, your lordship. The council is here to represent the case of Travancore Temple Board versus Bharat Post Employees Association on behalf of the petitioner along with the co-counsel and researcher. With the due permission of the bench, I would like to proceed with the statement of jurisdiction of this case. Your lordship, this case has been filed under Article 137 of Indian Constitution, read with Order 47 of Supreme Court Rules 2013. With the due permission of the bench, I would like to proceed with the facts of this case. But oblige your lordships. Your lordships, Sabrimala is a beautiful temple which is located in the state of Kerala between two rivers. And in this temple, there is a unique practice, that is performing 41 days mandala. That will be performed by male devotees with a male foot. They will be climbing the hills along with the mundu carrying on their head, and that will be covered with a black cloth, which signifies they have renounced all the worldly pleasures. But to protect the nature deity of this temple, who is a Naisika Brahmachari, and also to protect the reproductive system of the woman, they have imposed one restriction, that is prohibition of age of women between the age of 10 to 50 years. And for lordships, there was a case which is filed in 1991 itself, that is Mahendran versus Travancore Board Kerala. I would like to submit the judgment for this honorable court in the forthcoming arguments. And also, your lordships, based on these restrictions, the Bharat Association has filed a petition before this esteemed court and containing that these restrictions violate constitutional principles such as Article 14, Article 15, and Article 25, and also Section 3 of Kerala Authorization of Temple Act 1964. And also, your lordship, containing the argument posed by the petitioners, the respondents has contended that this restriction is solely based on the nature of the temple and also to protect the reproductive system of the woman. But the apex court has delivered the judgment in favor of Bharat Post Employees Association, appending that this restriction violates constitutional principles, that is Article 14, 15, and Article 25, and also Section 3 of Kerala Authorization Act 1964. So, agreed by the judgment passed by this esteemed court, the petitioner is hearing to file this review petition before this honorable court. If the bench is satisfied with the facts of the case, I would like to proceed with the issues involved in this present case. But oblige your lordship, in the present case, there are four main issues. The first issue is whether the review petition filed by the petitioner is maintainable or not. And the second issue is whether the Supreme Court erred in not applying the essential religious practices text to the Sabrimala temple, and whether the Supreme Court has failed to consider it as a religious denomination or not. And the third issue is whether the court erred in characterizing this age-specific restriction as an absolute ban or not. And the fourth issue is whether the judgment passed by this esteemed court has caused miscarriage of justice to the devotees of Lord Ayappa or not. Your Lordships, I will be dealing with issue number 1, 2, 3 of this case, and my co-counsel will be dealing with issue number 4 of this incident case. With the due permission of the bench, I would like to proceed with the adverse argument on issue number 1. But perhaps, Your Lordships, starting with issue number 1, whether this review petition is maintainable or not. Your Lordships, under Article 137 of Indian Constitution, the Supreme Court is empowered to review its own judgment. And under Article 47 of Supreme Court Rules 2013, in order to file a review petition, it has to satisfy two conditions. The first condition is discovery upon the new important matter of important evidence. And the second condition is apparent face of record. And the apparent face of record. And third condition is any other sufficient reason. And this review petition is filed on the first and second round, that is discovery of the new matter and also apparent face of record. This also includes the not consider the diverse Hindu practices and traditions in the Sabrimala temple, and also there is a misconception of discrimination against the women. And the fourth ground is interference with the religious faith and belief. And the fifth ground is there is a lack of discussion on the nature of the restriction of this temple. And Your Lordships, in order number 47, it has mentioned that only the Supreme Court can involve in the review petitions that includes civil and criminal proceedings. But there is no express provisions in the Indian Constitution that prohibits Supreme Court from reviewing the any orders and judgments that prevents the ends of the justice. In this present case, the Supreme Court has inherent power to exercise its jurisdiction and review this judgment passed by this esteemed court. And the grounds which I have mentioned above will be argued in my forthcoming issues. If the bench is satisfied with the issue number 1, I would like to proceed with the adverse argument on issue number 2 of this case. But oblige Your Lordships, the issue number 2 of this instant case is whether this esteemed court has failed to apply essential religious practices test to the Sabrimala temple or not. It is completely submitted that Sabrimala temple is a religious denomination, and this temple was constructed by Travancore king. And this is also evident from the official website of Ayappa Swami itself. And actually, the real owners of this temple and the family to whom the Ayappa Swami belongs is the king of Pandara Palace. I would like to read some history of this temple. If you look at the history of this temple, the king of Pandara family has paid some conflicts in the state of Kerala. During the conflict, they flee to Madurai in Tamil Nadu and they have become Pandyas. When this Travancore king came into the power in the state of Kerala, the Travancore king family and the Pandara family had a very good relationship. That is also evident from the Ayappa Swami official website itself. I would like to produce that copy before this honorable bench. Your Lordships, during the Malabar Coast War, they suffered huge loss in the state of Kerala. And to maintain those losses and to compensate those losses, the Travancore Travancore king has asked King Pandara to pay some amount of rupees in installments. And slowly as the days went by, the temple management is transferred to Travancore Devasam Board. And this Travancore Devasam Board is only the competent authority to maintain this temple. And even the Kerala government, in the case of Mahendran versus the Secretary of the Temple Devasam Board, the government even admitted that there was a board temple only authority to maintain and manage this temple that has been highlighted in the judgment itself. And your lordships, there is the majority of the opinion in the judgment passed in favor of the Bharatvarsh. The majority of the opinion states that the temple is being managed by the funds received under Article 290A of Indian Constitution. The funds received under Article 290A of the Indian Constitution will not take the right of a religious denomination. And this particular temple constitutes a religious denomination because the founder also in Malayalam we pronounce it as Pandalam, but in Tamil we pronounce it as Pandalam. So this Pandalam, the place also comes within the map of Trivandrum. I would like to submit the map before this honorable bench. And to your lordship, there is one more contention which was noted by the esteemed court, that is, this religious denomination doesn't satisfy three conditions laid down in the case of Shirur by 1954 and also in the case of SP Mehta versus Union of India. Your lordship, the followers of Ayyappa Swami devotees are known as Kandi Swamis, which is a unique name where no other temple devotees has this Kandi Swamis or Ayyappa followers. And they all follow the same dharma. Even though there are three different religions entered into the temple having a different faith, but they have the same belief of faith in the Ayyappa. And when they perform this mandala 41 days, they follow the same procedure imposed by the temple authorities. Therefore, this clause, even the esteemed court has ignored one of the dictionary meaning, Oxford dictionary meaning, where the religious denomination is beautifully elaborated. If you look at page number 21 of this memorial, the definition in Oxford Dictionary includes the action of naming from an or out of something or giving a name to or calling by a name. A characteristic or qualifying name given to things, clause of things. Here, all the followers of Ayyappa Swami devotees comes under the same clause. They also follow the same dharma, Ayyappa dharma. They have a distinct name also, Kandi Swamis. Therefore, they constitute a religious denomination, and also there is an evidence where the Taraka temple board has framed the rules and regulation being a competent authority. I would like to submit the same before this honorable bench. Your Lordship, just give me a moment. Your Lordships, therefore, it is evident that the court has committed error in not considering this supplemental temple as a religious denomination, and this temple has rights under Article 26, which gives right to the religious denomination to manage its own affairs. Even the same was held by this esteemed court, the case of Sankar Sahib versus Union of India, where the court has held no person has authority to interfere into the internal affairs of the religious denomination. Therefore, the supplemental temple constitutes a religious denomination, and also it has rights under Article 26 to manage its own affairs and to make rules. If the bench is satisfied with the arguments presented on issue number 2, I would like to proceed with the arguments on issue number 3 of this instant case. Your Lordship, the purpose of this instant case is whether the court erred in considering this age restriction ban as an absolute ban or not. Your Lordship, it is humbly submitted that this age restriction is completely implemented to to protect the reproductive health of the women. And there are research papers which has been, even there is one of the research papers published by the US government where they have said the reproductive system of a woman and also it may cause also the hormonal imbalance in the women biological process system when they climb the high altitude for a mountain. And this Saktimala temple is one of the mountains that is above 3,000 feet above the sea level. And for the same, I would like to produce some new important matter of evidence before this honorable court.
Below the sea level.
Above the sea level. And these are the research reports. Even one of the report is from official website of United States of America, and also I would like to produce two more reports. Your Lordships, not only based on the scientific reasons, even if you look at the Hindu mythology and Hinduism, there are totally 7 chakras. And this Sabrimala temple has Agnya chakra, which means at the 3rd eye point. And this Agnya chakra has a huge impact on the reproductive system of a woman. That is, it affects the pituitary gland of a woman. This pituitary gland is responsible for secreting one hormone, that is luteinizing stimulating hormone, which in turn secretes testosterone. If the testosterone hormone is high, if it is high up in the body of the woman, it may cause hormonal imbalance, which is also one of the reasons for suffering PCOD and PCOS. And this PCOS is a disorder. Even the PCOD can be curable. This PCOS is a disorder. It may cause infertility in a woman. And that is why every temple is constructed and the congregation of the temple has different chakras. And if you look, the root chakra is Muladhara chakra. And the second chakra is Vadhisthana chakra. And between the ribcage and the navel, the chakra is Manipura chakra. And the heart chakra is Anahata chakra. And the throat chakra is Vishuddha chakra. And the third eye chakra is Agnya chakra. This Agnya chakra, the Sabrimala is one of the examples for this Agnya chakra. Therefore, the intention of the temple is to protect the reproductive system and health of a woman. Even if you look at under Article 25, it is not an absolute right. It has some restriction that is limited to public health order morality. In this case, the temple is combined with those limitations, and they are trying to protect the health of the woman. And that is only the women who are belonging to the age of 10 to 50 years go through this biological process. And that is why they have imposed these age-specific restrictions. At the age of 50, the biological process of a woman may or may not stop. It differs from person to person because now we are living in a society where because of our lifestyle, there are so much of health issues that may occur earlier or it may delay also. So it is not evident that it will occur only at the age of 50. But this temple has made this restriction just to protect the health of the woman, and there is no intention to discriminate the woman based on the biological process. And even your Lordships, in this Sabrimala temple, the temple is known for Moksha Dana. That was noted by a great person, Sino Joseph, in her interview, she was also given the interview. I will submit the interview report before this honorable bench, where she has clearly mentioned why a woman should not enter into the temple due to safeguard her health. And Sino Joseph has also written a book where she has proved the restriction imposed by the temple is right for the purpose of protecting her health. Therefore, your lordships, it is evident from the evidence produced before this honorable bench, there is no discrimination against the woman, and it is clearly the respondents hearing, known as the Bharat Coach Employees Associations, has filed this bill in the interest of public, because the layman, whoever lives in this India, like even including me, myself, I am not well versed with the Hindu mythology, being a Hindu. And there is a lack of education of ancient times to the all the people in India. Therefore, they are not in the position to understand the chakras and the effects of those chakras. If there is an in-depth understanding of these chakras and how it impacts a human body, and also with the medical knowledge, they can understand that this is not a discrimination, it is only to protect their health. Therefore, it is humbly submitted that there is no discrimination, and the court, this esteemed court, has error in characterizing it as an absolute ban rather than an age-specific ban, and also to protect the woman's health. If the bench is satisfied with the arguments presented on issue number 3 of this instant case, I would like to call my co-counsel to present the arguments on issue number 4 of this.
Your Lordships, the Council seeks permission to proceed with issue number 4 of the instant case. Your Lordship, it is submitted that the issue number 4 is whether the judgment caused the miscarriage of justice to the devotees of Lord Ayyappa by disregarding the Hindu religions and practices. Your Lordship, it is humbly submitted that judgment passed by this esteemed court has caused a miscarriage of justice by disregarding the beliefs of devotees of Lord Ayyappa and disregarding the Hindu religions and traditions. It is humbly submitted that the judgment has failed to uphold the fundamental rights of the deity, where the beliefs and rights of the deity has been caused harm. It is submitted that the paragraph 103 to 106 on the rights of the deity, according to Justice D.Y. Chandrachud, the deity has no right to sue and to be sued, where the said legal personage cannot be extended for the purpose of enjoyment of the fundamental rights, where it is enshrined in Article 25 Clause 1 and Article 21. Where, therefore, your Lordship, it is submitted that this point misinterprets the submissions made on behalf of the deity. Questioning the character of a deity as a living person is a bedrock of Hindu mythology, and especially the mode of worshipping Sabarimala is itself a bedrock. Where the Hindus believe that after Prana Pratishtha in a temple, the deity has its own living body. The Hindus feels that the deity as a living person, where this has been disregarded by the judgment passed by this honorable court. There is one who saying that the deity has no legal status just because it can be sued and it can sue. There is no law limiting the deity legal status. Secondly, according to law, the deity is regarded as a minor, perpetual minor. It doesn't mean the deity cannot have the fundamental rights. For example, even in the case of Arjun Verma, in Competition number 718 of 2015, where the minor seek permission from the Supreme Court to vote out of the pollution-free air and seeking ban of bursting of crackers during Diwali, where therefore the deity being seen as a perpetual minor actually shows it treated like a living person, which makes it still the deity has the right like any other living person, since the fundamental right rights are not exclusively for adults. It was clearly evident from the case of Niranjan Vaikap and others versus State of Odisha and others. I would like to present this evidence before this honorable court. Your Lordships, on the issue, the remains passed by the Justice Nariman and Justice Hidayatullah in the concurring opinion in State Trading Corporation versus Income Tax Officers and others, the Lordship appears to conclude that the deity cannot have the fundamental rights under Article 25 Clause 1 is itself a patent legal error, which is shown in the research paper. I would like to present this before this honorable court. Wherein the Article 25 of the Constitution is itself provided all persons have a right. When deity is regarded as a juristic person, the general clauses of fact clearly mentions the person definition, where the person includes the juristic person also. When if we see in case of State Trading Corporation of India versus Commercial Tax Officer, the company has been regarded as a juristic person. Where in general clauses the meaning of the person is itself says that the person includes the juristic person. As in the case of deity, the deity also belongs to a juristic person. As a living person, he belongs to a juristic person. Has been laid out in the State of Corporation of India versus Commercial Tax Officers. Therefore, my lordships, it is humbly submitted that the deity has fundamental right, which is not considered by this honorable bench, and it is itself warrants a review of this informed judgment. If the bench is satisfied with the issue number 4, I would like to go for the prayer of the Celestial case. Therefore, in the lines of documents advanced and the authority cited, we, the petitioners, humbly submit that the honorable bench may be pleased to and admit this review petition and call for records of the case and set aside and review the petition passed by the petitioners. In any and pass any other order, direction, or relief that this honorable court may deem fit in the interest of justice, equality, and conscience. The petitioner feels much obliged to present the case before this honorable court. Much obliged.
Counsel seeks permission to approach the diet.
Yes.
Much obliged. The counsel seeks permission to The counsel seeks permission to address the bench, my lordship. Much obliged, Your Honor. The counsel is here to Council is here to address the bench between the Travancore Board and the Bar Ain Lawyers Association. With due permission of the bench, the Council wants to address the statement of facts.
Yes.
Much obliged, Your Honor. The Council.
That's we know. That's we know. What is this issue?
Much obliged. With due permission, I would like to proceed with the issues, Your Honor.
Yes.
Much obliged. Your Honor, I will be dealing with the first issue, and the rest of issues will be dealing with co-counselor. Much obliged, Your Honor. Whether unequal treatment of women from entering temples for the sake of upholding customs violates the right to equality under Article 14. Yes, it violates the Article 14. Your Honor, the Constitution respects the religion. It safeguards and protects the right of every individual to the choice of their faith. Religion is a holy bond between Atma and Paramatma. Now, who is that Paramatma? That religion on basis of any customary practice or any tradition is against the constitution. Yatra nayestu pujyate ramante tatra sarvatra devata, which means the God presence will profoundly found on where women were worshipped. Ironically, the woman itself subjected to made ban and disallowed to the temple on the context of menstruation. The stereotype individuality of discrimination is misogynistic in the religious institution. The faith and belief has the same power, either it is male or female. The essence of bhakti is the same. As the saying like, even the God shall also be born from the mother's womb. The greatest oath to the mankind to respect the woman. It is found in the many scriptures about the respect and tributes to the woman. The ban on restricting women, such basis is truly not only unconstitutional but also unethical on part of religion too. The discrimination is not the prayer, not by the God, but it is on the practice on worshipping the God only vested to men and ban on women. Your Honor, the dissolving of women from entering temples for the sake of custom is challenged so as to prove that it violates Article 14 and 15+3 of the Constitution on the grounds of sex. Prohibiting entry of women from age 10 to 15 amounts to untouchability. Untouchability is abolished, but since it is practiced in some more temples. The Senior Counsel at Supreme Court Indra Singh stated that prohibition of women entry is a form of untouchability as the sole basis of restriction of menstruation of women. To keep our menstruating women is a form of untouchability. Menstruating women are being considered as polluted beings. Your Honor, the Sabarimala temple, apparently most controversial temple in India, which was entry to women aged between 10 to 50 years old, saying that menstruating women are impure. Discrimination against menstruating women is common in some parts of South Asia. They are forbidden from entering their houses or temples and thus not taking part in the festivals and other community events. Your Honor, banning on this basis of age is not practiced in Hindu religion. The Supreme Court comments after the shining Singapore temple in Ahmednagar in the western state of Maharashtra opened its inner sanctorum to women. Following a Mumbai court that it was a fundamental right of women to enter any place of worship that allows male access and that state should protect this right. The Mahalakshmi temple, also in Maharashtra, followed suit and allowed women entry. In a separate case, two Muslim women are demanding access to landmark mosque in Mumbai. Devotion cannot be subjected to gender discrimination. It is challenged that the centuries-old tradition of Sabarimala temple banning entry of women of menstruating age has ever been stopped from entering this temple. Why do we forget that even in temples of Lord Hanuman, who as per mythological beliefs was backslid, yet no woman of any age ever been stopped from entering this temple? Your Honor, with the name of this God, there is a gender discrimination is taken place in this case. Untouchability was abolished, but this type of practice also an untouchability. Even menstruation, my Lordship, here menstruation is impurity. During the pregnancy of woman, we know the process how the woman gets pregnant. During the delivery of time, the blood is considered if menstruation is impure, every individual was also impure. Radha. my ignorance. Much obliged. It was argued that the Lord Ayyappan temple was not a separate religious denomination for the purpose of Article 26 because the religious practice performed Sabarimala temple at the time of puja and other religious ceremonies are not distinct and are akin to any other performed in any Hindu temple. The sole prohibition is on the basis of menstruation of women. To keep away women, the temple is practiced with the menstruation. Menstruating woman is a form of untouchability. In this case, menstruating women are being treated as polluted by the temple. The temple board, which violates fundamental rights under Article 14, 15 and 17 of the Indian Constitution, and the restriction on the entry of women in the Sabarimala temple is now here connected with the religious practice performed, where the question of the essence of the said religious denomination does not arise at all. In the case of denomination, tenets are important that distinguish it from an individual. With due permission, I will continue. The Ayyappa temple in Sabarimala, Kerala, prohibits women of menstruating age between 10 to 15 from entering it. Enforced prohibition enforced under Rule 3B of the Kerala Hindu Places of Public Worship Rules 1965 states that women who are not by custom and usage allowed to enter a place of public worship shall not be entitled to enter or offer worship in any place of public worship. If the woman removes her uterus, if they are allowed to the temple, no, since there is no measures. When the TTD decided to employ women workers about a decade ago, there was a stiff opposition from people citing Hindu scriptures which hold that women during menstruations are in an unclean state and hence must not touch devotees. Since it is impossible to tell when women are menstruating, the best solution was to bar women from employment as barbers altogether. With due permission, the rest of the issues will be dealt with by co-counsel. Much obliged.
Permission to attend the measure. Much obliged. The council's issue is Rule 3 of B of the Kerala Hindu Places of Public Worship Organization Entry Rules of 1965 is in violation on the ground of equality. As the co-counsel of the respondent team has already mentioned that in the TTD case, that is Tirumala Tirupati Devasthanam versus Balaji Barbers Association, there has been an entry to women barbers also who transferred the heads by irrespective of the matter of non-menstruation. They have been allowed the women also to transfer the heads to honor. And the justice system is not based on discrimination, it is based on the non-discrimination. The Sabarimala case is not in the view of conflict between two individual rights or group rights. The single absolute standard is prohibition of untouchability. And its forms, whether it's
TTD lady barbers, right? But there is no question of entry to the main temple, no?
entry to the main temple.
Barbers can do outside the temple.
In this case, you can reasonably beyond the logic that the entry was by the touching of the women barbers. After counseling, they will go to the temple. And in the meantime, anytime the co-counsel said that menstruation will occur. And
It's
it's
different. It's different.
That is
They are entering into
different.
temple. If they are entering into temple, that question comes.
Yes,
But here, male or female barber are only outside the temple.
outside the temple.
Or even the temple.
But after that counseling their heads, after that touching their physical presence, then only they enter to the temple. That after the counseling only, after that.
After the haircut is over, the male or female,
Yes, Your Honor. They
after
enter.
taking bath only
They will
they
take a
will
bath.
Yes, Your Honor.
take bath.
But in the meantime, there is no bar on the menstruation. There is no bar on such restriction. Yet menstruation is not.
Why there is no discrimination there? Why it is so? Even if during the menstruation period,
Yes, Your Honor.
the female barbers are allowed to
Stand on the heads.
Allow to like,
cut the hair,
Yes, Your Honor.
right?
Yes, Your Honor.
Because after that, they will then bath and go to temple.
Your
So
Honor.
they will become
There is
pure.
no question of applying this test to this test.
In this case, Your Honor, that the women are allowed to
They are only allowed
the workplace which is there in the religious institution, Your Honor. The workplace, that the women are allowed to the workplace which is there in the religious institution. They might not get any kind of menstruation bill.
there is no direct bearing on this case.
In this case, we want to conclude that menstruation is not the problem. That is the simple objection by respondent. Menstruation is not the problem.
There is a lot of difference between the present case and TDD case.
Yes, yes, Your Honor.
TDD case, we are not finding fault with other things.
Yes, Your Honor.
There, even if, but during menstruation period, the female barber can be there.
Yes, Your Honor.
There is no entry.
That is what the intention of the respondent is. The menstruation allowed in such temples. Where that
They are not allowed in the temple, outside the temple. Outside the temple.
There is no relevance at all.
Entry into temple, outside the temple is not of the
capital
That's important.
in the ancient Vedic state, recognize the principle of energy that gives energy to the deity called prana. Whenever the temple is constructed, we perform prana pratishtha. As example, in Ayodhya case also they have performed prana pratishtha. Meaning primal breath or life efforts that it is followed every such temple, either God or goddess. There is no discrimination in God or goddess, but there is discrimination in worshipping the God or goddess, either in praying procedure or whom to pray. In this, I want to produce some facts based on Ayurveda. The council produce the fact. In Ayurveda, there are three doshas, that is Vata, Pitta, and Kapha. Doshas are bioenergies that make every individual and help in perform different physiological functions in the body. The three types of doshas which correspond to the elements of air, fire, and water respectively. Each dosha has a primary function in the body, Vata, that is element of air, and moving force responsible for communication, perception, and cognition. And Pitta is held for fire, that is force of assimilation is responsible for metabolism. And Kapha, element of water, is force for stability. According to Ayurveda, menstruation is closely linked to the functions of doshas. Menstruation is regarded in Ayurveda as a special opportunity enjoyed by women for monthly cleansing. It is this monthly cleansing that accounts for female longevity. That is the buildup of energy in these days leading to menstruation starts. This buildup energy dissipated upon the body during the menstruation. During menstruation, Vata is predominantly as on the dosha, as upon the body. One of the element air functions of the Vata dosha is responsible for the downward flow of menstruation. During menstruation, women are likely to observe other energies in the environment. Whereas we allow in this temple, as though the temple is believed to be having the positive energy in the temple. It is a light that has been clearly mentioned in sacred books. Therefore, women are likely to observe other energies in the environment. Why can't they allow the positive energies which are created by the temple? And hence, prohibition in the Kerala Hindu place of public worship act is against of this. Women who are by custom to allow enter public place shall not be entitled to offer or worship in any way. Council seeks permission to go with the further issue. Thus, the exclusionary practice based on biological factors exclusive to discrimination. But as people, we inherited the legacy of human dignity. Else, when we gained independence, and that is where we have maintained our constitution with the highest principles and have adopted many constitutions. And the absolute non-negotiable relation of untouchability and discrimination is the bedrock of that legacy. From the inception, it is still on fight to eradicate such practices, either it is based on the caste or any other such things. The propagated untouchability and discrimination are being quoted to above the constitution. If mensuration is a defilement, we are back to speaking about ascriptive categories that militate against notions of human dignity, guaranteed in the preamble and reaffirmed by the Supreme Court's privacy bench. It is important to recognize that untouchability practices implicate women across the ladder of granted inequality in very specific ways, which is why this cannot be considered as a form of gender-based discrimination, but also to be untouchability. To further enhance the facts, I want to seek the council information to produce the evidences as evidential report, which is happened in April, Your Honor. I seek permission to proceed with the facts.
The temples are from this.
From other temples, where it is allowed.
So,
It is relevant.
you can also cite their ladies are not.
Where they
Or
are.
their male are not.
Yes, sir. Yes, sir. In the coming amendment. To further understand the aspect of not visiting temples during menstruation, the Devipuram in Andhra Pradesh,
So,
the Devipuram,
there you go.
the Andhra Pradesh, stands for the set out examples and stops the violation happening in dishonoring of women. Devipuram is a temple in Andhra Pradesh. It is dedicated to the Devi. Most of the priests are women. Who are free to be at the temple during the period time. In the temple, in the sanctuary of the temple. Though it is not forced, it is deliberately given the free choice of the individual whether to be there, in the sanctuary of the temple. There is a Kamakya freedom. At this temple, it is natural formation of the shape of yoni, that is vagina. Kamakya temple, Kamakya freedom. It is there in Andhra Pradesh. Kamakya temple is there in Assam, Guwahati. But Kamakya freedom is there located in Devipuram of Andhra Pradesh. That is the formation of the shape of yoni, that is vagina. And worshippers gathered here are not behind that period. And menstruation women are also so pure that she was worshipped as goddess at the time. Perhaps the most common version of all is that menstruation blood, that is considered as impure. It's a miscellany that it makes women impure. Interestingly, in some Indian cultures, the menstruation blood itself is revered, thought of as potent power. I want to cite page number 23 of the memorial, where there have been instances by our cultural practices from the ancient traditions we are following it. In the Manipur, the page number is 23. In the Manipur, there is a tradition. When a girl bleeds, the cloth into which she bleeds is safely kept aside by her mother and lifted back to her when she gets married. The cloth is believed to be so powerful that itself will protect the girl and her family from poor health and other ills. And an elderly woman in Manipur said in the book titled Folklore in India that they have taken a drop of their first menstrual blood as part of traditional practice. This blood was considered to be very powerful and believed to keep them in good health when consumed. In Dakshin Kannada, that is the state of Karnataka, there is a Tulu festival called Ketasa. This festival is celebrated in the month of January or February for 3 days. This is celebration of beginning of the mother's birth fertility, Your Honor. That is the menstruation. It is believed to be similar as women's fertility cycle. During these 3 days, Mother Earth is given rest and no disease or harvesting happens in this time. On the 4th day, some oil and turmeric is sprinkled on the earth such that the begins of process of sowing seeds. Similarly, it is believed that women are menstruating should also not to be disturbed during the period and our natural cleansing, downward flow of energy to be allowed before her next fertile phase begins. The culture is like close connect to the cyclic nature of the earth and women's cycles. The temple of the Bhagavati in Changalur is located in Kerala and the temple of Kamakya Devi in Assam where the goddesses too believed to menstruate and followed similar type of rituals of menstrual celebration, closing the temple for 3 days, only allowing a woman, and then celebrating the end of her menstruation. In these both temples, the menstruation cloth is considered as highly auspicious. They are not considered as impure. They are highly considered as auspicious, and it is distributed among devotees in the temple itself. The idea of resting or not disturbing menstruating women, including a goddess, does not arise from any superstitious belief. It is because the thought that menstruation and the release of energy during this time to be interpreted in such a way as discriminatory. It is their contention, Your Honor. It is natural cleansing process which happens to every woman in this country, in this world, wherever, that helps women remain healthy and should not be affected by external influences. Not all menstrual practices are derived from Ayurveda or such practices, Your Honor. There are some traditions that during menstruation they were practically following to the practical reasons. That is, the Golas tribe, Your Honor. I want to cite the page number 24, where Gola tribes practice is not because of the religious intelligence, because of their logical intelligent differential is there. I want to cite the example, Your Honor. No, much outline. Over 300 Gollas across 7 hadiths, that is hamlets in Hassan, Chitradurga district in Karnataka. That's the reason behind these practices. Whereas the women is untouchable or they will be isolated in these practices, when these categories mentioned, menstruation arises, woman is not able to touch or even to the temples. But these practices are different, which is happening in India itself. In one Golati, Asirke Hassan, it is informed that Gollas live in small houses with multiple families and also have the sheep under the same roof. Under such circumstances, a menstruating woman has little privacy and the space to manage her period. This belief that menstruating women have lesser immunity as a belief in their mind and are more likely to contract the diseases of the sheep, which live under the same roof at the same time. They do not have any means to provide separate rooms, which they are very poor nation in their homes for the comfort of menstruating women. Therefore, the community decided to build a separate at the time of menstruation time, where menstruating women comfortably and privately manage their period. Traditionally, these nuts were built out of herbal trees, such as neem and lime with medicine plants, which kept the women warm and prevented poisonous insects and snakes from entering. They revealed some interesting aspects of menstruating insects and snakes from entering. They revealed that it is said that Gollas being shepherds were primarily nomadic in nature. The men traveled with the sheep, sometimes for months together, in search of work, food, and for the sheep benefit. When they returned, they naturally eager to have sex with the woman. And with a thought about the woman's current condition, that is, the rest during the menstruation time or in the pregnancy, since the contraceptives are available, and that is the reason they have made the separate houses to build. Because when Gollas tribe went for a long period, they don't know that whether the wives in their home are having menstruation or not. They suddenly have the feeling after seeing a long gap and they try to intimate. For such reason, the wrong sense of menstruation is considered as an intimate time. They have built separate houses, and that tradition has historically following as misogyny that women should be held separate. Women should be treated as isolated. Because of that reason, at those times, they held that concept called isolation. But now it is not considered as impure or any such. Your Honor, any such matter. And that
Mean that the tradition should be respected.
tradition is always respected here because there is no harm, there is no gender inequality here, and that has the reason the tradition has respected here, Your Honor. That is actually better as a positive discrimination where women are allowed with reservations. That is the concept of positive. There is no harmless in the gender inequality or any such caste system, the reservations are there. Here also, in the traditions also, there are beyond logical reasoning, there are examples which set out the superstitious matters that must be eradicated in the name of God, in the name of religious mind. And for this, the counsel stated that in the first issue that about the pituitary gland. I want to give the scientific evidence Against yes, the book from the Sabarimala and Henry Kapoor written by Samuel Johnson. It states that
You want to give scientific evidence?
evidence as per section 145, produced under section 46 of Indian Evidence Act, expert opinion.
Expert opinion.
Expert opinion.
Chalo. Who is that doctor?
Dr. V. Bhuja Reddy is the intern junior in Hitman. I want to also seek permission to produce the
Yes, yes, some.
and counsel stated that it is because of the pituitary gland and the artery. But both were different. Pituitary gland is different from the artery concept. That is the chakra. We call them as shed chakra. That is different. And pituitary gland in the medicine thing is totally different. Simply they are managing. You are trying to convey to enter into the new facts as they have mentioned under Article 137 probably they need new evidences to produce to allow the petition in the court. They are trying to portray.
They have come up with the USA evidence. You are coming with Indian evidence.
Evidence is evidence.
Evidence.
Evidence is evidence in the matter of any country or any. No,
They have not said it simply, but they said based on American experts' opinion.
it is based on Indian expert opinion. It is followed.
Yes.
It is followed in India, not in America.
But in America, our results are being followed.
That is why the army is there in the institution for it. And they should be considered as upheld. The bench.
Make in India is valid.
This is go ahead.
Clearly state that the science behind the sample ban of certain age is due to hypothalamus. That is the release of gonadotropin, which stimulates the releasing hormone. That is a psychological defect, and that depends upon individual, not on every particular body. And they in the temple they have certainly made a restriction on certain age category. But here they are stating that it is a ban for all women. The Sino-Joseph book, it stated that it is ban on women. No woman should enter such temple because celibacy is nature of the Shed Chakra. The Shed Chakra also affects between the age of 9 and above the age of 50. Because every woman is having the same uterus and the same pituitary gland. And hence, as the pituitary gland releases the gonadotropin, which are FNH and LH probably the man counselor are hiding this fact that FNH and LH are more responsive. FNH is folate stimulating hormone which stimulates the growth of ovarian follicle. And that is N. Growing folate releases the estrogen neuron. Because Madam Counsel stated that it is a spermatulation that is depending upon menstruation cycle that happens, reduces the power of reproduction. Instead, the women are having more energy at the time of menstruation. They can allow from the temple and accept the wife for all wives to the temple. Hence, as this testosterone is produced in the lower levels in the woman, they are considered as impure. And such conditions, it is not based on the religious text or religious wherever. And suppose the testosterone is converted to estrogen neuron, as scientifically I am saying. Suppose the testosterone is converted to estrogen, which inhibits the release of FS and LH, then there will be no development of follicle. And if no follicle, there will be no menstruation as per their contention. And that is actually against the nature of the it will never happen. Hence the scientific reason and intelligible differentia and rational nexus objects thought is banned on the protection of health human condition, but as not on menstruation. I can consider as them as a impure and or any sort of discrimination is not there in this case. Even there is another thing that in a month practicing mudra, it is noticed that the menstruation cycle had suddenly shifted about 13 days, which is unusually synced with the earth and moon cycle. That is the reason the Amavasya or the Paurnami which exactly happens in every 30 days. That is a thing beyond this scope. In that scriptures only it is mentioned. The atoms came through our body and the co-counsel said that region is the essence of Atma and Parma. Atma can be anyone, either child or elder, either female or male. This will constitute the supreme soul authority called Parma. And this, with this concept, I want to brief about some more facts which is definition part, Your Honor. Counsel seeks permission to go on to the definition part, Your Honor. That is, they are stating that the bank was only the negative representation.
Putting Ayurveda evidence also.
Much objection, Your Honor.
Can you cite Veda evidence also? Evidence from Veda.
Yes, Your Honor. That is like evidence is there in the project. But predominantly I want to state
Yes, yes.
and the definition part itself is wrong. That is the reason. What is Naistika Brahmacharya in this context? I want to say. What is Naistika Brahmacharya means? There are several types of Brahmacharya in India. Yeah? The petition policy is only based upon Naistika Brahmacharya because you know only that Brahmacharya. And what is Naistika Brahmacharya is that transcends principle or committed Brahmacharya. That means someone who is avoiding the practice of Brahman, not Vastu. Brahman means here, but the attempt of access of Brahman or consciousness, super high consciousness, or predominantly everything. That a person who refrains from all worldly pleasures, desires or attachments. There is nowhere mentioned that women cannot have the same renunciation. There are women where they renunciated, like Mahamata Gandhi is there. She learned all the Vedas, the meditation time. She was learned from the Vedas from the Vedavyasa itself. It is not considered as the pure discovery stated by the British. Naistika Brahmacharya is itself stated faithful or committed because Naistika means which is stated as Na plus Naistika. That is Naistika. And Naistika means the rule which has been set by themselves. There are situations where my co-counsel stated that about Hanuman. Hanuman is also called as Brahmachari. He will be called as Astalita Brahmachari. In fact, more than Naistika Brahmacharya. And there itself the Ugra entering
Brahmacharya, Naitika Brahmacharya. Both are.
Naistika Brahmacharya. But some people are wrongly pronouncing it as Nastika Brahmacharya. That is totally different in this context. Hence, such differences is made by their psychological scriptures and it is not in the Vedic period of and suddenly they come up right in the name of laws after the constitution about the section 3 of B in the Hindu Authorization Protection Act and suddenly they appeared in the name of religion and there is no prominent prescription prescribed notion which states about that the menstruation time at this certain age group should certainly have menstruation process. There are instances where a 9-year-old girl can have menstruation and still allowed to enter the temple. And there are instances recently a 65-year-old woman gave birth in the age of 65. Where that is considered as menstruation practice begins there and ends there. So it is not about their age restriction, it is not about the gender discrimination, it is about their psychological depiction that has created this chaos and barbaric situation. Among the women, it is rational and dignity or locus can be that they are not supposed to enter women on such bar basis because in the case law it is believed that materially process, women should be considered as maids. Where the bar gender should be their philosophy. Our community was there where they be considered women as their maids. And they are part from their community itself. And I want to certainly make sure that why the name Sabarimala came and how it came. Sabarimala actually, the man counselor given some documented evidence which is not produced to us. It is essential court practice to give a copy of the respondents.
You didn't ask us.
I
You didn't ask us.
updated now. It is
Not for the copy, when they rejected, then it is their mistake.
it is there. The part is it is not there. They should update a copy to us. It is their duty. Yes.
That is the duty of the petitioner to submit the copy.
To copy, Your Honor.
So they have done
So
mistake.
that they have done mistake. It's okay. I want to correct the mistake, Your Honor. Please.
They want to argue on their own point of
It is their mistake. I want to correct the mistake because there have been a fact that has been clearly stated that the Sabarimala
You can only bring the counter evidence, but all now. You cannot hold them to do their evidence to you to argue in our favor.
because the council seeks permission that the under Article 137, whether any new matter of protection of evidence only, then only the petitioner should be allowed. And since this fact, they are producing unnecessary evidences which were created falsely and certainly that I need to the respondent need to take
Necessary are fought to give him evidence. Why they will give?
But the evidence should have the validate, Your Honor. Validate. And such validate is Sabrimala temple. The name of Sabri itself is a woman. Sabri, the name of origin, Sabrimala temple. But Sabri is a woman. It is there in the Ramayana scriptures, Your Honor. I am not stating.
They will woman.
That is not woman. That is what our context, Your Honor. She should be allowed. It is what our context is.
Silence. Maintain high silence. Do you have the list of temples where male or not allowed?
Male or not? There is a temple called Rajasthan, Your Honor, where married men are not allowed. Married men, only married men, Your Honor.
Men or not? Do you have any evidence for that? Scientific evidence or customary
It is
evidence?
only customary testified or content is such conventions which are discriminatory against our constitution without any biological evidence must be condemned and eradicated from the society. That is against the scriptures, it is a false statement that I am developing these facts throughout the book and canon of our India. Whether the patriarchal society or anything, giving more priority to them, Your Honor. And such facts must not mislead the court. That's what our attention is. And it is stated that about ancient temple Sabrimala. Sabrimala temple is one of the oldest existing temples in India. Absolutely, Your Honor. Historians and archaeologists have studied deeply about the temple, its construction pattern, and the interpretation of the legends associated with Sabrimala, etc. And suggested that the temple is at least built by 4,000 or 4,250 years old. But according to popular belief, the temple is 4,800 or 5,000 years old. The ancient place is of great importance. It is there mentioned in the sacred Ramayana, where everyone knows. Where Bhagavan Sri Rama and Lakshmana met holy woman called Sabri. And the famous Vishikya Mukha Parvat is also situated in the banks of Pampa. That is no Pampa River, Your Honor. It is situated in the Ayappa temple, located there, where the Manda king Sugriva take refuge from his evil twin brother Bali, and Bali was chosen by the sage Matanga. If he dared to step on this mountain, he would die on the spot. It is actually the discrimination was on the many of the family read that the woman should not allow. From their scriptures only, we are citing, Your Honor, that it is constitutionally upheld, but socially also to be upheld. That necessarily producing these facts would not only mislead the bench or the constitution or the civil justice of law, but also the people of India who are leading the faith, Your Honor. With all these examples, I want to go further with the third issue. Is Sabrimala temple having any denomination character? That is the main question done by the council. They infuse our constitutional order with the vision of a future of just, equal, and dignified society. Whenever Supreme Court rules a judgment, in any sort of judgment, there are 5 essential qualities. That is the just, that is the equity, the principle of just, fair, reasonable. But in this context, only again and again the approaching the review petition, and after that we dismiss the review petition, again file the curative petition, which is more beyond that, to the complete justice, because of this false implications which are cited in the above contentions, Your Honor. That is, the intrinsic to these values is the anti-exclusion principle, exclusion of distinctive of dignity. To conclude, a woman from point of worship is fundamentally at the heart of constitutional values. Because briefly argued that women between the ages of 10 and 50 are not allowed to undertake the pilgrimage or enter Sabrimala on account of impurity associated with the menstruation. The stigma and around menstruation has been built up around traditional beliefs that the impurity of menstruation of women, hence they have no place in constitutional order, in the constitution of Bharata, Your Honor. These beliefs have been used to shackle the women, to deny them equal entitlements and subject them to the dictates of patriarchal order. Hence, the dignity of women is questioned here, whether they are to be allowed the menstruation time, which is a natural process. Even the God itself is also born from the mother's womb, and the womb is created in the menstrual time, Your Honor. That is what my co-counsel has been briefed in this honorable bench. If that itself is considered as an impure, and that itself is not to be allowed in the temple, then no man or no woman is not to be allowed to pray or worship in the temples, because we all come from the same pillar. That is the menstruation egg ovary in this context. Your Honor.
It is impure, all are impure.
Yes, Your Honor. We have held that the devotees of Lord Ayyappa do not constitute religious denomination, and that Sabarimala temple is not denominational temple. The provision has application, which the Honorable Supreme Court has uplifted it. The notifications which restrict the entry of women between the ages is filthily false in the malicious content. And they have prevented any woman between the age of 10 and 50 who are having the same pattern of period. I have cited that below. The periods are subjected to individuals. When they come, no one knows. It is highly impossible to predict the dates of the period. And for this, I want to raise one objection question: that on what ground, on what solid ground, they have created this age restriction, which is against the gender discrimination, which is against the violation of their own religious scriptures. On what ground they have continually mentioned the age category, that is from 10 to 50 years.
So already heard their arguments are.
They didn't set the ground for this. But they are resolving of women always cited that the menstruation process. But the menstruation process begins in any age, depends upon the individual, not on the age of 10 to 50. The response question is as simple that why is the age restriction of 10 to 50 has been mentioned in the rule?
Actually, they have cited reason, that is religious statement. But you are ignoring that.
But that is the religious statement which is psychologically they give us, which is against the
Not only psychological, they have quoted the American stated that
I have been quoted the Indian temple.
only to protect the reproductive system that countries and restriction is involved. Only to protect, not to discriminate women, but to protect the woman. Right? Reproductive system is concerned. They made this restriction, not with any bad intention. They have already answered on this one.
Yeah, they are defecting on their part. I have mentioned from Ayurveda where Vata is. In itself, they mentioned it as a highly obstacle. They have mentioned considered the nature process, and it is to cleanse the women. It is to cleanse the women, not to isolate or not to ban on the restrictive parts of the temple.
They are not isolating, they are not discriminating. What they say is to protect the reproductive system of the woman.
Yes, Your Honor.
This condition is important.
And that has been reversed.
What about the benefit of woman?
It depends upon individual because many Indian women boxer.
No, I tell you this.
Much of benefit.
After the Supreme Court judgment, starting to rule, you are right.
Yes, Your Honor.
How many female have entered into Sabarimala temple after the judgment? Basing on this judgment, how many female have entered into the temple? Forget about the menstruation period, this, that, and all.
Yes, Your Honor. That is the benefit has been
100%, I know that 100%, I'm sure during menstrual periods, no woman will go to any temple.
That is a wrong belief, Your Honor.
90% confined to house to safeguard their health, right? But so far as the temple is concerned, during menstruation, they voluntarily restrict themselves not to enter into the temple. During non-menstrual period, have you cited any cases where they have been prevented?
Yes, Your Honor.
Now, after this case, the judgment is given in favor of you, but how many after this?
They have entered.
Seeking the help of the judgment, how many people have entered into the temple?
Your Honor, it is based on the
We
individual. We are giving the opportunity to the individuals. Your Honor. It is not that the women should enter or not the contention that women should not enter. We are giving opportunities to the individual.
.0005. 0.0005. Right? May try to. But the rest of the 99 point, so they are not interested to enter. Whether during menstrual period or during non-menstrual
That
period.
interested to enter is against the brief of their own standard institutions. That is what our attention, it is not only unconstitutional, it is also part of unethical
It can become unconscious because they have to have a fundamental right.
Yes, Your Honor.
Religious right.
Everyone is protected and having the same fundamental right, Your Honor. Either women or men. That is what our matter is. If they are having a fundamental right.
Don't discriminate saying that woman and men.
Yes, Your Honor.
You look at the point of view of the religious rights, which are guaranteed under the Indian Constitution. Suppose you may have a fundamental right,
Yes, Your Honor.
as per you, but as per them, they have to have a fundamental right guaranteed under the same Constitution.
That fundamental right should not harm the other gender or other race.
How?
Other freedom.
Then what for
The
this?
disallowing of the temple based on the woman and certain the psychological character of the
The freedom of religion itself is having some discrimination. It should be always there is no freedom of religion. How can there be a provision in the Constitution protecting the rights of religion?
The freedom of religion can be given to individuals. But that freedom should not be violated on the part of Constitution. Laws which are, Article 13 says that, laws which are inconsistently judicial review.
Again,
That is their own right.
see the framers of the Constitution, they know very well about Article 13, Article 14, right? Article 32, 226, 227, all framers of the Constitution, they know very well. By knowing this fact, why the fundamental rights related to religion are also guaranteed in the same part.
Your Honor, there is a case called caste discrimination, which is happened from many areas.
No, if it is not related to religious freedom,
We are people are studying caste discrimination questions.
sir, if it is not related to religious freedom, then we will accept your argument.
It is not.
Now, there is a conflict between, maybe, but I don't find any conflict between, but you may say that there is a conflict between fundamental rights, right to enter, and they to have a fundamental right guaranteed under Article 27 Part 3, protecting the religious rights. Right?
Protecting the religious right.
If, according to you, there should not have been a provision related to freedom of religion.
There are no rights called.
No religion.
Even fundamental rights are having exceptions, Your Honor. The bench knows it is of the power.
Every right is having a duty, that is general question.
Yes, Your Honor. But that duty is respect for its honorable bench, the discretion power of court. That is the violation. That is a violation.
Do you think that court will not go wrong? Do you think that court will not go wrong? That's the reason why they
I will give an example.
petition.
I will give an example, Your Honor. Courts are never wrong when they follow my conditions. In any sort of judgment,
Then why
there is a principle of equality.
Yes, yes. Now I will come to your point.
Not sovereign, Your Honor.
The lower court what it says, why appeal will go to the higher court?
If the religious belief
From magistrate court to district court. From district court to high court.
Yes, Your Honor.
From high court to supreme court.
And that is the declared
Saying that means that even a judge may commit error. Because they are also human beings like us.
Certainly, Your Honor. Certainly, Your Honor. But respondent's contention is not that the judge is committing mistake. Yes, sir.
See what I want to say.
Yes, Your Honor.
If the court is not honoring the customs precedents prevailing in the country,
Yes, sir.
if they give judgments based on fundamental rights, as you said,
Yes, Your Honor.
ignoring the freedom of religion under the same part,
Yes, Your Honor. Yes, Your Honor.
right? What happened in Jallikattu case?
Yes, Your Honor.
What Supreme Court has done?
That is also happened in
Is there any steps taken by the government or by the state or central to prevent Jallikattu? That is the reason why I say The public will, not the case and the judge.
Your Honor, the same reason
The judge, you have to gauge the public will and the public to wants. Then only the judgment will be respected. The judgment is ignored by the public. What will get happened?
Yes, certainly pointed out this question, and I want to brief it about the same religious belief. The caste discrimination is also there, and we all accept it. But there was,
So you respect the freedom of religion.
if this respect of freedom of religion should be there, that the gender should not be allowed. And the caste discrimination is also to be condemned as a protective right to them, Your Honor, and that is violation of.
Can you differentiate between the religious rights and the rights in the religious rights? The general rights and the religious rights.
The religious rights are those customary practices that have been vested to the individual are part of the subject to protective of the dogma, religious dogma upon the deity. Upon the deity, the council has which respectively Madam Chairman, that is followed by other. As the bench is certainly noting, saying that.
You want to say that in the name of deity they are doing like that or not?
Yes, Your Honor, that is what I am contending. The bench has certainly noted the point.
No, I'm not. Still doubt and putting questions. Not satisfied.
Your Honor, they are saying that the Madam Council is saying that it is not may or may not.
I have one. I concur with both the opinions, okay? But how far the women are interested to access or go to Sabarimala temple? For that question, law is a customary practice.
Yes, sir.
So it takes time to go for Sabarimala temple. It is my personal opinion because
Yes, sir.
when we are, a grown-up stage like 10 years or 15 years, then we used to see that only mother cooks and washes dishes. But nowadays, all are doing the same. The male person, that is the brother is doing same, washing of dishes, etc. So it takes time to go for Sabarimala temple also.
Yes, sir.
First, the court has, I cannot say at this time whether it is good or bad. It is my personal opinion. But I can say that the judge, for the implementation of this judgment, it takes time. But definitely and surely it will get success.
Yes, sir. That is what our whole contention is. If it starts from here, then it takes a lot time. I want to cite this some beautiful example.
Women employees, we cannot notice that, 20 years back. But now 33% reservation are there, and the employment, they are taking up employment,
Even,
and they are working against dowry.
even the third example is even the marks are obtained by girls, Your Honor, more in increasing pattern of male students.
But it will take time.
But still it is considered, yes, it takes time, Your Honor, but that time should not be prolonged in the name of writ moral, judicial writ moral. They are coming from the lower court, and again higher court. And the Supreme Court has been given issue that it is unconstitutional. Again they file the review petition. And if this review petition also dismisses, Your Honor, provision has been there, contained in the law, to file a review petition.
They file to protect the customary practices, age-old practices.
Which is reserved to the open
Practices.
The customary practices which are followed by
Not only to protect the customary rights, as they said, it is to protect the productive system. The productive system.
Yes, sir. It is,
Now, come up with the.
but that should not be, there is no clear cutly mentioned any temple, deity. The religious place is a religious place, no?
No, certain see,
Yes, Your Honor.
in Vastu, they say that temple in the house should be in one particular place.
Much obvious.
Kitchen should be in one particular place. Right? It is purely scientifically they have
Yes, Your
decided.
Honor, I accept it, but one condition, the bench has been certainly pointed out that this particular question, the opposite opponent, and counsel, they cited about the US constitutional or US rights to hear. That US rights go off the chapter, Your Honor. We get close to what Maharashtra is and how she looks, but still they are rights, Your Honor. Much obvious. Counsel seeks permission to proceed with the prayer.
we should not put questions after the prayer. More questions are there. We have any reply from you?
Yes, sir.
The sad side. The sad side.
Your Lordship, the learned counsel, number 1.
Now, first I want to have some notes, let's say, like the respondent of the defense. The evidence which you have produced over as protecting the reproductive system. I want to know a little more on that. Is it really to protect the reproductive system, based on which the women are not allowed into the temple, or it is based on the customary procedure?
Your Lordship, coming to your question, our main intention is to protect the health of a woman. And the learned counsel has mentioned in no, except Vedas, there are no other Hindu mythology states that menstruation is impure. There are Smritis which states menstruation as an impure, but the petitioners has not discriminated it as an impure. And the learned counsel has stated that the petitioners are misleading the bench. So I would like to produce that document evidence also. And this cannot be said as a false evidence since it is. Your Honor, during rebuttal, it is a rule that the learned counsel should not interrupt the petition.
The extent they take it.
And
These are all the evidences.
And also, Your Lordship, the learned counsel has mentioned that the temple has considered the menstruation as impure and polluted, and it also violates Article 17 of Indian Constitution. Your Lordships, the Travancore Devasam Board, who has created the rules and regulations, they have repealed this untouchability in the year 1955 itself. For the same, I have the proof, and this cannot be said as false.
Not the question of untouchability.
No, it is not such form of untouchability.
It is not
in the name of gender. There is difference between them.
The learned counsel has contended it is a violation of Article 17. Even the majority of the opinion which was passed by this extreme court did not consider Article 17. I would like to mention that there is a proof it has been already repealed and they are combined with the fundamental rights.
We don't accept the violation of Article 17.
The majority of the opinion did not accept the violation of Article 17. As the learned counsel has mentioned that the petitioners are misleading the facts of the case, I would like to present the facts with the evidence.
It's not right to mislead, but we are here.
And also, Your Lordships, the learned counsel has mentioned there is a temple in Rajasthan which prohibits entry of a woman inside the temple. Your Lordships, it is very pertinent to note that it is very pertinent to note that the married men are not allowed inside the temple, not all the men. As the learned counsel has mentioned, the petitioners are contending prohibition of all the men. No, our contention is to protect the health of a woman, we have imposed the age restriction that is 10 to 50, which is the prohibited stage of a woman. Woman has this biological process. Men doesn't have this biological process and they can attain moksha dhamma. Satyana is a temple which is known for moksha. And that is also evident. And also, the learned counsel has mentioned only one temple that is not allowing men inside the temple. and I would like to produce the list of temples where men are not allowed. That is Adukal Bhagavati Temple, Kerala, and the second temple is Mata Temple, Assam, and Devi Kanyakumari, the Devi Temple, Kanyakumari, and Kamakhya Temple, Assam. And your lordships, not only the female with a bed is not inside the temple, even a male with a wood is prohibited to enter into the temple. When male is performing 41 days mandalam, that time if the male faces any death or birth in the family, he is not supposed to enter into the temple. He has to stop the brother, and he is prohibited to enter into the temple. And there are temples where men are not allowed. If women are not allowed inside the temple, amounts to gender discrimination. Then men who are not allowed inside the temple are also, it also amounts to gender
But it
discrimination.
is the failure of the man not filing the writ. It is before the separation.
But the temple board has wanted to invoke its fundamental rights and file this review petition to protect the miscarriage of justice to the devotees of Lord. And the Lord Council has mentioned about body weight.
But you mean to say that there is no discrimination as such?
There is no discrimination based on the gender. And also I have produced clear evidence where how the woman health will impact when she climbs the high altitude hills. And the temples which they have mentioned where the entry of the woman is allowed. Those temples are situated on the mountains.
Do you have any expert opinion
Your lordships,
on this time from 10 years to 50 years? Do you have any scientific evidence on that?
your lordships.
Then by experts.
Your lordships, the review petition has been filed. When I argued on my first issue, I mentioned there is no inquiry into the nature of the temple. Under Section 45B of Evidence Act, the esteemed court has failed to obtain expert evidence because the court has authority to get evidence from expert, and that is the court's discretion. And the court has not obtained the expert evidence. Rather, they have appointed the application juries to inquire into the matters of the case. And that is also one of our ground to file this review petition. And even your lordship, I don't know whether it is right to mention here or not. This review has been filed by the temple people itself in reality. And the Supreme Court has allowed the petition. And they have also framed 5 questions and referred it to 9 bench judges, which is still pending for you.
So we are lesser than.
That is all.
Your contesting that there is no discrimination as such being followed by the temple.
There is no discrimination. The intention of the temple is to protect the reproductive system of the woman.
How are the objections? What is your objection?
The council stated that.
See, from 10 years to 50 years, not allowed. It is not the question of absolute restriction. It's only a partial restriction. So as to protect the reproductive system. There are only a partial restriction for the benefit of the woman.
Not to protect the reproduction, that is in the name of religion they are saying.
That is not the reason. See, why 10 to 50 years? Very nice, you tell me.
That is what our question is. They are not also religion. They are just
There is a scientific way. That is the reason why from 10 years to 50 years.
connected with the scientific reason, Your Honor. Yeah, connected with the scientific reason. That's not to be part of scientific, Your Honor.
Even American evidence also given.
But the bench has accepted it, Your Honor. When I have with the bench itself, and then produced it.
You have not accepted it.
To produce evidence, Your Honor. To produce evidence. And it is highly stated that this etc. concept is not comes under scientific evidence.
Won't come.
It won't come, Your Honor. Etc.
Why there is a
It has no.
why there is a partial restriction from 10 years to 50 years
That is what, Your Honor.
without any scientific evidence? No, without any scientific evidence, you say that.
Religious dogma, Your Honor. Religious dogma.
Yes,
Dogma.
yes.
It is practice. Dogma, religious dogma.
What you say, is it a religious practice or it is scientific basis for putting this condition?
If that is so, your lordships, the learned councils have mentioned Vedas. And that is also doesn't have scientific evidence. When these,
Scientific published.
and also the council has mentioned,
Do you have a scientific evidence?
yeah, the scientific evidence
Yes, you have.
is, report is how the women's reproductive system affects when they climb high altitude hills.
Your Honor, Bhattacharya Fall is the one first woman to climb a mountain.
Something about get affected.
The architect, I am mentioning it.
Mundu on their head.
The pituitary gland.
When they carry Mundu on their head, it will stress, and also there is a scientific evidence where the problems in the reproductive system of a female causes due to the stress that occurs in the pituitary gland that releases the hormone which I mentioned previously.
Yes, Your Honor, it depends upon it.
That affects the reproduction.
That depends, that means, I have a question here. If we remove the uterus, then they will allow. If we remove the uterus, there are women who have not had uterus. Operation process. Then they will allow the temple. Then they will allow the uterus.
Only 10 to 15 they don't know.
You are
Between 10 to 50 only, Your Honor.
What he said that when if we remove the uterus, then
when
there is no problem of this impurity, there is no concern. The question of impurity, whether he will allow the
Definitely they will allow.
because they
That is what they have accepted.
What we call exception in exceptions.
Going beyond exception, the most
Suppose that the reproductive system itself is removed.
Yes, Your Honor. There is no.
We go with an evidence that reproductive system is removed and then to the management of the temple. If they are not allowing, that amounts to discrimination.
Your Honor, there are certain practices in the temple. I want to just
They must know, the people must know. Reproductive system is removed or not, they must know with evidence.
there is no proper evidence. There is no clear-cut evidence. There is acceptable evidence. Even when they are whatever they produce, they have to be thought as substantial part of evidence. It's not of
Any petition is filed and even the judgment was
favored.
and also doubt on this. That is the reason why it is referred to the larger
The
bill.
science itself stated it is exceptions of exception. More than exception is more doubt. Your Honor. That is, being and counsel stated that after this, there is a temple called Tenshik now. In the temple, located in Ahmednagar, in the western state of Maharashtra, opened with inner sanctuary to women. Your Honor. By the honorable bench decision.
Okay, some of you
I have one question for. There are instances where women have visited Sabarimala. Yes, sir.
yes, your lordship, they are
No. How can you justify those instances? That's what only I want to know. Because you can do nothing with that visits, etc. So how you can justify those actions and restrictions upon the age group that is 10 to 50?
by educating a woman with a lot of
No. My question is, how would you interpret, how would you define the situation where women have already visited by violating this 10 to 50 years of age restriction? That's what, just.
your lordship.
Even one, female actress, I think, one, I don't know names, but there are instances where women have visited and one ceremony also has been conducted, maybe Kanshur or Aksharabhyasam, I don't remember, but one instance has happened. Then what about this principle, 10 to 50 years of age restriction? Is it not applicable to those DIPs? No. As a petitioner, I am just out of curiosity.
Your lordship, there is a clear-cut answer which was passed in the case of Mahindran versus the Secretary of Devastan Temple Board, where the chairman, who is above the age of 50, she is a female, and she has attained the menopause, and she is a female who is the chairman, and they have filed a case before the Kerala High Court, and the Kerala High Court upheld in favor of the temple only. And what was the reason for filing the cases by the petitioner Mahendran is they have allowed the granddaughter of the chairman inside the temple. That is also evident before this court.
Things happen in that the child, as per they mentioned, consideration process, it is again some etc. All that various stimulation. Something after the moment.
Child is before the
Even she is alive. There is again only and given.
I do sum up the arguments, then I will ask. Sum up the arguments.
1 minute, man. Just why I have followed the question is only how you have prepared for this. That's what I want. Okay?
As you said, if we will go to LTT, okay, then pituitary gland will affect it.
Your lordships, this like for the bench clarification, given not only the pituitary gland and the other scientific reasons, as I'm not well versed with the science knowledge, being a lawyer, I would like to mention one point that is also mentioned in the report is that the oxytocin level will be lower in the high offense. That will also be a reason.
It will be affected. It will be affected to 10 to 15 because see, if it is a minor, they will be having same problem. There will be some breathing problem will be there, as you said.
After attaining the puberty, the woman has this creation of living species nature, which a male doesn't have the biological process. And that is not here specifically mentioned, even though it is mentioned as 10 to 15 in supplement, even now, they are verifying whether the woman is completely pure inside and outside. Pure in the sense, whether the woman has attained menopause or not. After considering that only they are going inside the temple. And for the same, I have the evidence, but it is in electronic form, which I will submit before this order. As I am not supposed to use now. Much of that.
Permission to attend the bench. The managed petitioner has been stated that it is a pituitary gland, it is in the oxytocin. But pituitary gland does not release the oxytocin. There are dopamine, etc. which are there. That is by other part. But it is certainly not by oxytocin. And other person is budgetary part, the first one, who climbed with more higher altitude. That is Himalayas. The Pai temple is somewhat, I think, altitude between low range and Himalayas. Women are climbing Himalayas. It's not certainly objection to person that suffering not tested. Lower middle part with it. It is certainly, we must object that this is based on the religious practice. And there is another convention that is very old. Who was the boxer of the Indian team has been literally practiced when she has become champion when she has a loss of menstruation. At the time of menstruation, she practiced and hence in the competition on one many gold medals to India. That is not just stress. Depends upon the individual. And that individual should not be back to all the government. That is what highly concerned is and the court is on discretion power that the respondent is treated to uplift the previous judgment which is given by the Honorable Supreme Court and uplift the same as proceeding which is given to it. Much obliged.
Students should have start. Students, you want to go for to answer your natural class, you can go. After 15-20 minutes, we will start final rounds.